My name is Bruce Provan. I'm the Managing Director of Page Provan Family and Fertility Lawyers. We're a firm of lawyers in central Brisbane which practices exclusively in family and fertility law. We have clients from all over Australia, in fact all over the world. I practice exclusively in family law and have done for many years. I'm sometimes asked the question, what if your ex breaches the parenting orders and what can you do about it? So if parenting orders are made, it is possible to take action to have the other parent dealt with, in other words, punished by the court for breaching the parenting orders. But you've got a few options, and making what's called an application for contravention to have the other parent punished may not be the best option. If you do make an application for contravention, you need to very carefully word the application to set out the times, dates and places where the order has been breached. And if you're successful in persuading the court that the order has been breached, the court has a few options. They can impose penalties upon the other parent. Those penalties can include a fine, bond. It can also include, in extreme cases, imprisonment of the other parent. But the court has a discretion in each case, and the court may decide that even though the other parent has breached the orders, that they're not going to impose a penalty. Another thing they can do is to make an order for make-up time for the time that you lost through the other parent breaching the orders. But I generally say to clients, think long and hard before making an application for contravention, because it may not be the best remedy. And even if the other parent is found to have breached the orders, it may not necessarily solve your problem. The alternatives to making an application for contravention is an application to vary the parenting orders. Now, I've heard one of the judges say that one of the difficulties with applications for contravention is that they don't solve the underlying problem. And the underlying problem is that the parenting orders, whether they're made by consent or made by a court, just aren't working and needs to be changed. And in fact, if you make an application for contravention, the court has the authority to be able to vary the orders. In other words, if they think that the order's been contravened because the parenting orders are not appropriate, then they've got this discretion to vary the orders. And it's not uncommon for a parent to make an application for contravention and end up with less time with the children than what they were having. The other alternative to either an application for a contravention or an application to vary the parenting orders is what's called parenting coordination. And that's a process where parents consult with a qualified parenting coordinator to try to address those issues that are leading to the contravention. In other words, working with the parties to come up with an agreeable plan to get the parenting arrangements working rather than letting the matter proceed to court, because obviously going to court involves considerable expense, especially if both parties are represented by lawyers. So if the other parent is contravening parenting orders, it's important to get advice from a lawyer who specialises in family law at an early stage to discuss your options. If you're watching this on YouTube, thank you, and please subscribe to our YouTube channel. My name is Bruce Provan, Managing Director of Page Provan Family and Fertility Lawyers.